number of articles in the labor code on collective bargaining, you will find that there are very few articles on collective bargaining. Article 250 up to Article 253-A, that's all that you find. The reason why the law contains a minimal number of articles on collective bargaining is the simple reality that collective bargaining is not law. Collective bargaining is labor economics. And you will note, therefore, that since the law recognizes it not as law, but as labor economics, the concentration of the law, therefore, on the labor code begins first with the basis for the right to bargain collectively. And the basis for the right to bargain collectively is found in Article 13, Section 3 of the Constitution. Because Article 13, Section 3 of the Constitution enumerates among the guaranteed rights of workers the right to bargain collectively. Statute-wise, meaning the labor code, that constitutional guarantee is reiterated in Article 211, big A, small a, when the law says it is the policy of the state to promote and emphasize the primacy of collective bargaining as a mode of dispute settlement. So, the first thrust of the law is laying a basis for the right. So, by judicial doctrine, the right to bargain collectively is both constitution and statutorily guaranteed right. The next thrust of the law is to lay down a procedure for the parties to negotiate. But you will note that as you read Article 250 and Article 251, you will note that the law allows the parties to agree on the procedure for negotiating a contract, subject only to the limitation that it must be more expeditious than that provided for by law. You will note the element of voluntarism is preserved. However, should the parties be unable to agree, then by automatic provision of the law, Article 250 will apply. Article 250 is the procedure for collective bargaining stated in the labor code. But the heart of the entire matter is Article 252 and Article 253. Article 252 is going to be manageable if you are able to cut it down to its component parts. First, Article 252 provides for a standard of behavior mandated by law, which means the behavioral patterns of the negotiating parties are closely scrutinized by law because Article 252 provides for a measure of standard of conduct. Second, you will note that Article 252 also defines the meaning of what are the negotiable issues in collective bargaining. And lastly, you will note that Article 253 is closely related to Article 252 because Article 253 is an extension of the meaning of the duty to bargain. And finally, you have Article 253-A. Article 253-A provides for the duration of a collective bargaining agreement. There are opener clauses. Now you have a complete picture. So you have actually a roadmap. Your roadmap tells you that this is the forest of the law on collective bargaining. The specific articles are the trees making up the forest. You therefore cannot be lost on your way. So, no, there's a constitution guarantee on the right of the worker to bargain collectively. And that guarantee is implemented by the Labor Code in Article 2.5 and is implemented by the Labor Code in Article 211, big A, small a, because the law's wording is to promote and emphasize the primacy of collective bargaining as a mode of dispute settlement. Therefore, it is fixed in your mind that since the right to bargain collectively is guaranteed twice, the fundamental judicial doctrine says the right to bargain collectively is both a constitution and a statutorily guaranteed right. That now takes care of your foundation. But as you read the procedural requirements, there is only one rule. Yes, the parties can voluntarily agree on the procedure to be followed in collective bargaining. But should they not agree or they are unable to agree, meaning they negotiated but failed, or would prefer to opt to follow the procedure provided for by law, then by automatic operation of the law, Article 250 will apply. But you will know that Article 250 is a procedure, but the procedure begins with the proposition that there is no such thing as a verbal demand and a verbal counter-proposal. It must be in writing. Second, because there are time frames with reference to reply as well as submission of proposals and counter-proposals, the provision of the law on time frames has been interpreted by the court to mean that it is directory, meaning a failure to comply with the procedural time frames does not give rise automatically to a presumption that there is an unfair labor practice. But there is one particular provision in Article 250 that you should focus your attention to, because in Article 212 of the Labor Code, there is a term called board, and the board is defined as the National Conciliation and Mediation Board. And you will find the functions and the scope of authority of the board in Article 250. But Article 250, with respect to the role and function of the board, must be read in the light of Article 233 of the Labor Code. The two go hand in hand. So as you analyze Article 250, you will notice that the board's function is limited only to conciliation and mediation, never as an arbitrator. And secondly, the board can, if all else fail, if all efforts on mediation and conciliation should fail, the board can only recommend that the parties submit the case or the dispute to voluntary arbitration, but never as an arbitrator. Now, since the board becomes a participant in the negotiating process, what is the entry point? The entry point is the board may be invited by one or both the parties, meaning the employer and the union, to mediate and conciliate their dispute. Or in the alternative, the board on its own can enter the negotiating process. The moment the board has entered the negotiating process as a mediator or as a conciliator, certain prohibitions are now put into place. Namely, while the board is performing its function, neither the employer nor the worker or both can do any prejudicial to the mediation and conciliation process. Second, to give effect to its power, the board is given the function and authority to issue subpoenas to compel the party, A, to appear and participate, and second, to produce all documents in their possession necessary for the success of the mediation or conciliation process. But the overall writing consideration is, how do you encourage the parties? And by way of encouraging the parties, you have Article 233 referring to privileged communication, which means A, any and all information disclosed or discussed during the mediation and conciliation process are deemed to be privileged communication, meaning they cannot be disclosed nor admissible in evidence in any court of law or any tribunal or any agency of the government. And secondly, whatever is disclosed, whoever participated in the mediation and conciliation process, be they public or private individuals, cannot be forced to testify on any matter discussed during the mediation and conciliation process. And should the case go to arbitration one way or the other, an arbitral award cannot be based on the basis of disclosures made during the conciliation and mediation process. You have therefore taken care of the procedure. But now you have to reckon with Article 252. And Article 252 is the heart of the matter. Article 252's first sentence says that the meaning of the duty to bargain in good faith is the parties must meet promptly, expeditiously, and in good faith. However, the last sentence of Article 252 says that neither party is obligated to agree to a proposal or a counter-proposal. But you have to read the first sentence as well as the last sentence of Article 252 in the light of Article 248 and Article 249. Article 248 refers to the unfair labor practice that may be committed by an employer. And Article 249 refers to the unfair labor practice that may be committed by a labor organization, which means it is an unfair labor practice to refuse to bargain in good faith. Clearly, there is a relationship. Secondly, a close reading of Article 252 will tell you that the law likewise defines what are the negotiable issues in collective bargaining. So, a reading of Article 252. And if you were to play a crystal ball gazing, the question that can come out would be, what do you mean by the duty to bargain in good faith? Now it is a little tricky, but it is manageable. First, the meaning of the duty to bargain in good faith is couched in very positive terms. The word used is to. Therefore, it's positive. You must meet and confer promptly and expeditiously. But at the end of the sentence, you will find that there is a statement to the effect that neither party is obligated to agree to a proposal or a counter-proposal. This time, you meet that duty couched in negative terms. Negative meaning there is no obligation to agree or to disagree. The question now is, how do you connect the two? The positive statement, the difficulty is good faith. But the good faith or the badness of the faith can never be decided simply because it's a state of the mind, as long as what one of the parties is thinking is simply left in his mind. There is no indication of good faith or bad faith, right? But the moment what is in the mind leaves the mind and it is translated to a conduct, then you have a measure of good faith or bad faith. And the measure of that good faith or that bad faith in relation to the last sentence is, it is therefore incumbent a duty on the part of the negotiating parties to fully explain the reason why they cannot agree to the proposal. Meaning, there is a mandate of law requiring the parties to fully explain their respective positions, so there is no violation of the meaning of the duty to bargain, considering the fact that if one explains his position, then one has not violated the standard of behavior. So what was once in the mind is now translated to reality, but the reality says, I cannot because, and it is fully explained. That's clear. So therefore, you must be introduced to two concepts. First, hard bargaining. Hard bargaining or hardball bargaining is not prohibited by law, simply because it is a common standard of human behavior that one would want to get the pay, or one would want to get at the least possible cost if you were the buyer. If you were the seller, you would also want to get the maximum that you can get in the market. It is therefore bargaining on how you arrive at a mutually acceptable solution. Clear? Now, the next area of concern of Article 252 is the meaning of the term, what are the negotiable issues? Jurisprudence tells you that whatever is provided for in labor standards law namely Books 1, 2, 3, and 6 are non-negotiable issues, meaning these are statutory floors. These are minimum conditions that the law deems necessary for the welfare of the worker and the family to maintain them an opportunity to have a decent living. Any negotiation, therefore, for terms below the statutory floor are void ab initio. From the very beginning, they are void. What then can you negotiate? What are negotiable are conditions over and above, plus PLUS, what the minimum conditions are. But the law defines them to be wages, hours of work, and other terms and conditions of employment. Wages, you only follow one guide. Wages does not mean money paid today only. It also can include money or anything of value payable at some future time, specifically a pension or a retirement fund. And even if the pension or the retirement fund is funded solely by the employer, there is still a duty on the part of the employer to negotiate. Hours of work. Hours means day, time, additional compensation, meaning over and above what is provided for in Book 3 of the Labor Code. But there is one phrase there which is vague in the beginning, and that is the phrase which says other terms and conditions of employment. By other terms and conditions of employment, it is so vague, so general, that anything can fall within that definition. The definition, therefore, of the phrase becomes material. And it is this: proposal, counter-proposal on the one hand. What is the nature of the business of the employer? Is the proposal or the counter-proposal related to the nature of the business? If it is related to the nature of the business, by definition, it forms part of the phrase other terms and conditions of employment. You have therefore identified what are the negotiable issues. Nothing, however, will prohibit the employer or the union from voluntarily discussing any and all issues, subject only that you cannot negotiate what the law provides as minimum terms and conditions of employment. Now, you are introduced to a new concept. What do you mean by mandatory and non-mandatory or permissive issues in collective bargaining? In other words, hours of work, wages, and other terms and conditions of employment, are they mandatory issues, or are they merely directory or non-mandatory issues? So that you do not get lost. Your framework is there is a definition of what are the negotiable issues. The question is, how do you classify these negotiable issues into mandatory or non-mandatory or merely permissive? Immediately, you must bear in mind that making that distinction has legal implications. The first legal implication is there an unfair labor practice if one party or both refuses to negotiate the issue? Why? Because a refusal to negotiate in good faith is an unfair labor practice under Article 248 and 249. And immediately you are faced with a problem. Is there a ULP if I should decide not to negotiate? Second, up to what time can you keep on negotiating? Meaning, can you reach an impasse? An impasse is, despite all the good efforts, despite all the good intentions of the employer and the worker, they could not agree. There is no meeting of the minds. And if that point should ever be reached, can I now avail of economic weapons? Strike on the part of the worker, lockout on the part of the employer. So you now have an equation to follow. So you now make a choice. Is it mandatory? Is it not mandatory? Obviously, you'll have to make one choice over the other. If the choice made and your guide is there a connection between, and you claim that it is mandatory, then there is a mandate of the law which says negotiate under pain of ULP should you not negotiate. Automatically, therefore, the cloud of the ULP is hanging over the head of the negotiator. Second, can we keep on talking and never agree? Meaning, when can we reach an impasse? The moment there is an impasse, you now ask, did they bargain in good faith? Impasse is, we agree to disagree. If we agree to disagree, are now economic weapons available? Economic weapons meaning strike and lockout to force one of the parties or both of the parties to abandon a preferred position. Therefore, you have the equation. The other half of the equation says, if the issue is merely directory, then there is no duty to bargain. There being no duty to bargain, there is no fear of ULP. There is even no fear of the use of economic weapons. But should the party agree to negotiate a directory or a non-mandatory issue, the standard of behavior of Article 252 will automatically apply. Clear? Now, having said that, if that particular area was asked in the bar examination, what is the distinction, if any, between mandatory and non-mandatory areas of collective bargaining? Now you have Article 253. But Article 253 says that the meaning of the duty to bargain laid down in Article 252 is extended further. It means that during the last 60 days of a collective bargaining agreement, which is the period that one can file a petition for certification election, or the contract has expired, the contract continues in full force and effect until a new CBA is signed. When the law says the contract continues in full force and effect until a new CPA is signed. It means from page 1 to the last page of the contract is in full force and effect, meaning neither party can selectively choose which part of the contract is enforced, which part of the contract is not enforced. Clear? Now, you are left with only one article, Article 253-A. You will note that there is only one case deciding Article 253-A, and that is the case of Rivera versus Espiritu. If you do not want to remember the title of the case, it is the Philippine Airlines case. Now, what does Article 253-A provide? Article 253-A provides for a maximum duration of a collective bargaining agreement. And by definition, in Article 253-A, the maximum period of a collective bargaining agreement is 5 years. However, note it says the maximum, which means the parties can negotiate for a collective bargaining agreement of a lesser period. But if there is a 5-year collective bargaining agreement, or less than 5 years, the majority representation or the recognition clause is fixed for that period mentioned as the duration of the contract, meaning no one can challenge the majority status of the exclusive bargaining representative in the interest of stability. However, you will note that while it says a period of 5 years, there is a next sentence which says, not later than the 10th year. All other provisions of the collective bargaining agreement may be renegotiated except the recognition clause, meaning the determination of the exclusive bargaining representative. Clear? And then the law says, since there is a reopener clause, the reopener clause is not automatically mandatory, meaning the parties may agree not to reopen, but there is a window of opportunity to reopen because there is the provision which says not later than 3rd year. Now, 2 time periods are now mentioned. If the parties reopen and agreed within a period of 6 months from the time they agreed to reopen, the retroactive date of effectivity of the reopen clause is at the time they began. But should they fail to agree within 6 months, then the parties have the burden of negotiating the period of the effectivity of the contract. Now, since the maximum duration is 5 years, or whatever period they agree, can the reopen clause go beyond 5 years? Because obviously, if you reopen on that 3rd year, there is a remaining balance of 2 years. The court made a distinction. If the parties renegotiated, that means they bargained collectively, meaning it cannot go beyond the 5-year period, meaning only the unexpired portion of the contract. However, if the dispute is settled by compulsory arbitration, the law makes a distinction between a negotiated contract and an arbitration award. If it is an arbitration award, it can go beyond the 5 years. That's Kisunding versus that's the Manila Electric Company versus Kisunding. However, going back to Article 253-A. Article 253-A, according to Rivera versus Espiritu, is designed to provide stability as well as predictability. Predictability meaning the period for the filing of a collective petition for certification election is predictable during the last 60 days. But the court went further. It is also designed to provide stability. And therefore, the court said the parties can opt in the interest of Philippine Airlines financial security in this particular case, that the parties are not obligated to bargain, meaning the parties can waive their right to bargain collectively in the common interest of saving a distressed employer. You will note that historically, Philippine Airlines was in the process of closing on the ground of bankruptcy. In order to save the company, Article 253-A was interpreted to mean that the parties can waive. Now, every collective bargaining agreement must contain, under Article 260, a grievance procedure. A grievance procedure which provides for the methodology of settling any labor disputes, naming the arbitrator in advance, or in the alternative, indicating the procedure for the selection of an arbitrator. A normal collective bargaining agreement should contain items on wages, hours of work, and other terms and conditions of employment. The beneficiaries of a collective bargaining agreement are all the employees, and the term employee is defined in Article 212, provided they belong to the appropriate bargaining unit, meaning the contract beneficiaries can include non-members of the union because they are part of the appropriate bargaining unit. In the case of how do you interpret, you follow the general rules of interpretation. And finally, a collective bargaining agreement is a contract in personam. It is not a contract in rem enforceable against the whole world. It is enforceable only against the signatories. It is enforceable against other parties, not signatories, if you can prove that there is fraud. Do you have any question before I leave it? You should know the basics. 2, you must know procedure. Thirdly, you must know the standard of behavior, the negotiable issues, and the mandatory and non-mandatory. And finally, you should know Article 253-A as interpreted by the Supreme Court in Rivera versus Espiritu. To be safe, you can take a look at your books. You can take a look at your code and take a look if there is Rivera versus Espiritu. Number 2, samahan ng mga manggagawa sa tapo. If it is there, you are safe. Take a look. For your own insurance. In other words, I'm trying to tell you that it is an insurable interest. You take a look, is it there? If it's not there, buy the insurance by annotating whatever you have. And take a look at your notes. Is there any area that you would want to be discussed? Is there any other area that you would want to be discussed as part of the law on collective bargaining?
Reg.
Take a look. Alright, take a look at Article 250 and then Article 253.a, and then indicate if there is an area that I did not explain, I am willing to go back. Yes.
Sir, when we respect about reopening the process, we want to have clear explanation.
An estimate?
No, sir, can you repeat
Yeah.
with respect to the
Take a look at Article 253A. Alright. The introductory sentence tells you that there is a maximum period or the duration of the collective bargaining agreement. And it tells you that the maximum period is 5 years because you cannot open the recognition clause. Recognition clause means the employer recognizes XYZ labor union as the exclusive bargaining representative. That portion is sacred for 5 years. Thou shalt not knock, thou shalt not open. If you want to put it in biblical terms, do not knock, do not open, because even if you knock, it will not open. Right? But then, maybe I illustrate it better. You bring out, if you have a coin, bring out your coin, a 1 peso coin. Then you can understand what it means. You bring out a 1 peso coin. Go ahead. Here. A reading of Article 253 tells you that the collective bargaining agreement contains economic provisions or other provisions, right? If the contract has a 5-year duration, at the time you sign the contract, there is a value to your money. Meaning, in simple arithmetic, 5 pesos is 500 centavos, right? In simple arithmetic. But after you've signed the contract, there is a possibility that the purchasing power of the peso has gone down. meaning the 1 peso of 100 centavos of today next year may only be worth 90 centavos. There is a loss of 10 centavos, right? That's why you have a reopener clause, to try to restore the value of the centavo that was lost, to equalize. Now, but there is a carrot and a stick. The stick tells you to not negotiate who is the manager, a union, right? Negotiate all other things. Then there is the carrot. If you renegotiate not later than 3rd year, in fact it's grammatically wrong, because not later than 3rd year means tomorrow you can negotiate if you signed it yesterday, right? The law now says, if you renegotiated and you agreed within 6 months, then the renegotiated contract will retroact to the day you began bargaining. In other words, there is an inducement, there's a bribe, if that's what you want to call it, if you agree early enough, right? But if you agree beyond the 6 months period, then you have to renegotiate the effectivity day of the renegotiated contract. The question is, if you renegotiated on the 3rd year, just to make the simple arithmetic, the unexpired portion of the contract is 2 years. Can you renegotiate for 3 years? If you do, you have extended the contract to 6 years, right? So, the court made a distinction. If it is a renegotiated contract, it cannot go beyond the unexpired portion. Otherwise, you would have lengthened the duration of the contract. But there is what is known as an arbitration award, meaning it was subjected to compulsory arbitration or even any form. That means the parties did not negotiate, which means in this particular case it was a compulsory arbitration award and therefore can go beyond that 5 years. Now, that is Meralco Kitsumbi. The second case involves the case of Philippine Airlines. It's Rivera versus Espiritu. And it was interpreting again Article 253-A. Article 253-A was interpreted to mean that it is a law designed to provide predictability and stability. Predictability because there is a time frame available to open majority status, which means going further, the court said nothing in Article 253 prohibits the parties from agreeing to waive the right to collective bargaining, including the right to file a petition for certification election. Why? But you must know, Rivera versus Espiritu is a case sui generis, or I should avoid using Latin terms. Rivera versus Espiritu is a case in itself unusual. Why? Philippine Airlines was on the verge, in fact was going to close. And you very well know that Philippine Airlines is vital to the economic life of the country. In fact, it went through a long process. I am sure when you were students in your sophomore year, you would have discussed Rivera versus Espiritu till Kingdom Come. And you are aware that it is a very special case. It is an attempt to save Philippine Airlines, and therefore the law was interpreted in such a manner that Philippine Airlines can be saved. Clear? All right, any question? I repeat, I have tried to put it in the blackboard, the salient features, and it is not difficult for you simply because there are only 4 or 5 articles of the Labor Code that are applicable. Clear? All right. May I ask you to read Article 212 of the Labor Code on the definition of an unfair labor practice? And may I ask you to read Articles 248 and Article 249?
Papatayin. Hindi na hina. Hindi na siya may hina. Papatayin. Parang bigyan ka.
All right, that's nothing difficult drawing. In fact, you can ask your pre-week body viewer to use the blackboard so that it's going to be easier for you. You can ask your pre-week body viewer to diagram it so that it is easy for you and to correlate. All right, so begin with reading Article 212 on the definition of an unfair labor practice. Just read it. It's a very simple one-sentence definition. An unfair labor practice is any act defined in this code as an unfair labor practice. I repeat, an unfair labor practice is any act defined in this code as an unfair labor practice, which tells you if it is not defined in the code, it is not an unfair labor practice. Here. The next is read Article 248 and Article 249 very slowly. You just read it very slowly and you will find that it is worth an investment on your part to read it slowly in the light of Article 212. All right, now here, 212 says, an unfair labor practice is any act defined in this code as an unfair labor practice. The acts that are defined as unfair labor practice are found in two articles, 248 and 249. But you will now note that Article 248 and Article 249 are all designed for one specific purpose. The purpose is to maintain and intact the right to self-organization, the right to bargain collectively in Article 13, Section 3 of the Constitution, which means 248 and 249 are designed to protect these two rights. 248 and Article 249 refer as background Article 13, Section 3 of the Constitution. One, the right to self-organization, the right to bargain collectively. Second, a reading of Articles 248 and Article 249 will tell you the parties that can commit the act are identified. Article 248 says it is an unfair labor practice for an employer, and the term employer is defined in Article 212 of the Labor Code. Article 249, on the other hand, says it is an unfair labor practice for a labor organization, and the term labor organization is defined in Article 212. But in addition to the labor organization, there is the use of the word officers or its agents. Officers are listed in the Constitution and bylaws. Agents are not. But the law says, by way of interpretation, that the principal-agent relationship need not actually exist. Clear? So you have identified who are the violators. You have also identified your background. Now your background becomes true and real. Read paragraph A of 248 and paragraph A of 249. All right, read it very carefully. 248 says, it shall be an unfair labor practice for an employer to interfere restrain, coerce employees in the exercise of their rights guaranteed by law. 3 words here in the blackboard: interfere, restrain, coerce. Employees in the exercise of their rights guaranteed by law. What are those rights? Self-organization and to bargain collectively. On the other hand, in the case of Article 249, paragraph A, it says, it shall be an unfair labor practice for a labor organization to restrain or coerce employees in the exercise of their rights granted by law. Exactly the same, but the word interfere no longer applies in Article 249. 3 words in 248, 2 words in 249. The reason is, if the word interfere were there, anything the union does will be considered interference, and so the union function is totally obliterated. Clear? But you will now note, common to both is in the exercise of the rights guaranteed by law. But nowhere in the labor code will you find the definition of the term interfere, restrain, or coerce. None. The labor code did not define it, which means the ordinary dictionary definitions, the ordinary dictionary definition of the word interfere, restrain, or coerce is the acceptable definition. It's not technical, right? So, from that paragraph A, you now can draw a doctrine. An act is unfair labor practice if and only if the act is designed to interfere, restrain under Article 248 or coerce. Under Article 249, restrain and coerce the employee in the exercise of their right. Second, the act may be unfair according to your own conscience, but it is not necessarily an unfair labor practice. Correct? So, if you were to put the 2 articles side by side, you will now find a degree of commonality, meaning the same phrases are used. But you will also find that the same phrases may be used with slight differences. And thirdly, you will now also discover that there are certain acts which only an employer can commit. There are certain acts which only a union can commit, right? Now again, read 248 and 249 very carefully. And you will now see it is not really very difficult. It is like eating peanuts. Peanuts is good for the memory, according to the advertisement. Now read it very carefully. All right. Now, what is the connection between paragraph A of 248 and paragraph A of 249? There is a direct connection, except the word interfere does not appear in 249. But restrain and coerce appears in both. Right? So, what is the connection between 248A, 249A in relation to the rest of the subsections? Look at the structure again of the nomenclature of the law. What is the relationship between paragraph A and the rest of both articles? So here is the answer. The connection is very simple. Paragraph B down on both sides are examples of the meaning of interfere, restrain, or coerce. Acts done over a period of time by the employer and the union. They are merely examples. In the language of the law, they are derivatives. They came from experience demonstrating interference, restraint, and coerce. That therefore, what is the value? The value is this. If any of the acts B, C are committed, automatically there is a violation of paragraph A, right? But then you must know this. The act is violated only if the trust of the act meaning, what are it? The labor code ULP is violated only if the trust of the act is to violate the guaranteed rights, correct? Which means then, what if it is not enumerated? The point is, the lawmaker does not have a mind to be able to foresee any and all acts. It is therefore left to those who interpret the law to interpret the meaning of interfere, restrain, and coerce, which means what? Interfere, restrain, and coerce is one size fits all. It's a blanket, like the blanket of Linus, for those of you who read the comic strips. One size fits all. Which means then, if you do not know the answer, and I hope it doesn't happen, then you can seek refuge. Yes, because it interfered, it restrained, and it coerced employees in the exercise of the right, and then you explain why. Right? Now, again, going back, you will note that there is a provision that contracting out may be an unfair labor practice. May I ask you to read Article 106 of the Labor Code? A reading of Article 106. tells you that contracting out or independent contractor is a valid business act. But if you read the labor code on ULT, you will also notice that it says contracting out is an unfair labor practice if the work contracted out is performed by union members. And second, by contracting out, it will have a negative effect on the workers' attitude towards the union. Why? So you balance the two. Contracting out is perfectly legitimate business, correct? But you have to reckon with the fact that if the act or the work is contracted out, would there be interference? Would there be restraint? Would there be coercion? That's why it says there is going to be, if the work contracted out is done by union members, and the effect of contracting out is to want the worker, you behave, otherwise we will contract out, right? Behave means do not join the union, right? Clear. You noticed it. But on the other hand, you have Article 249 on feather bedding. Feather bedding is an act on the part of the union to coerce the employer to pay money or anything of value for work that is not done. Of course, it is an economic way of protecting your business interests. Clear? Clear. Now, take a look again at the law. All right. Supposing you are all invited by the personal manager and he asked you, di ba UST graduate ka? And then he'll tell you, well, you know, UST is a Catholic institution, is God-fearing, right? It is good that you went to UST, you did not go to UP. After all, UP produces atheists, non-believers, that are radical. And then he says, ano ba naririnig ko? And you say, ano ho yun? And then he says, union. Says, UST, you are God-fearing, should not be believing in these radical things, right? If you are a UP graduate, I would understand. After all, if there is no revolution and no quarrel, there will be no UP. Right? Okay. Has the employer interfered? Has he? Of course, you have an answer. After all, we have a very fertile imagination. Whether there is one or not, just remember one thing. The law is protective of the two rights, and any attempt to violate it, there is a high danger that there will be collision. So if you go back to your classroom days, you have heard, at least for those of you who are reading old books, Lena Micalier and Philippine Steamship Navigation. What do you mean by interrogation? Can you inquire? And number two, can you put up the defense that I have the right of freedom of speech, a constitutionally guaranteed right? Well, that cannot be asked in the bar. It cannot be asked because it's a very complicated question. All you are expected to know is the structure of 248 and 249. plus the fair notice that the lawmaker did not intend, because they cannot conceive of any and all acts that will cover the meaning of interfere, restrain, and coerce. It is left, therefore, to those who administer the law and adjudicate it in controversies. All right. It's 1 hour and 45 minutes since we began. You want a break, I'm sure. All right, you can have a break. Let me end up, before I proceed, by saying that an act may be unfair by your conscience, but it need not be an unfair labor practice simply because the term unfair labor practice is technically defined. Clear?